Thank you,
JR?
Ann. Thank you, Ann. As always, great job. Thank you so much for everything you do, organizing things and just being a great director, manager over at the Contra Costa Bar. So as she said, I'm the current chair or president of the real estate section for the Contra Costa Bar. And we've got a great lineup of CLEs this one. And next month, we're going to be doing one on 1031 exchanges. Last month, we had landlord tenant law. So we have a whole year of great CLEs for you. And they're the third Friday of every month. As soon as we can, we're going to get them back in person again, just like breakfast. Scott's is no longer open, but we're looking at venues as we're talking just now. It's really my pleasure to introduce our speaker today, Ann Woodsum. She has extensive commercial leasing experience over 20 years. If you take a look at her kind of book of business, it relates to complex leasing transactions, representing large institutional landlords, high-tech tenants, life science, retail, and even some smaller leasing issues as well. I think that I met her through the California Lawyers Association, and from the moment I met her, couldn't help to be impressed with, I mean, I don't know how she does everything that she does. She organized and founded a women in leasing seminar. I think it was a couple of days. Last time I went to it was in San Francisco. Fantastic event. I think she's going on 8 or 9 years with that. She's also doing this global commercial real estate leasing series. Did you do that in October? Is that when that?
Yes, it started in October.
Yeah. She organized our spring conference at one point single-handedly. I think I've seen her speak about at least 4 CLEs. I think my favorite one thus far is where she dissected the problems with the commercial lease and the air.
AIR.
Yeah, and the air.
I can't. Right? Don't even speak to me about the car form.
Okay, all right. So it's just the air.
that can't be spoken about.
But it's interesting. You could take a form that a lot of people rely on as kind of, the way to do business, and have somebody go up and basically say, nope, 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 nope. And this is the reason why you can't use this, because this stinks. And if you're really representing somebody well, this is the way you'll go. So that's why I approached Joanne to come talk to us today. What we're talking about here is top 10 tips for reviewing commercial lease. If you're like me, it may not be your primary place of business or primary area of business. So these tips will be really helpful for somebody like me. And by the way, so I just wanted to add this. Joanne is not only qualified to practice law in California and Nevada, but is also a solicitor in England and Wales. That happened like a year or two ago, right?
Right, last year.
Okay, so it's going to be at one point or another, like, what country can't she practice in? So, I mean, it's going to be... Anyway, my pleasure to introduce Ann Woodsum. Thank you, Joanne.
Great. Thanks, JR, so much for the kind words. As JR well knows, I am a total leasing nerd. I love leasing. I'm a solo practitioner. I've been 100% leasing since 1999, so a really long time. Before that, my practice included other areas, but I early on decided I just wanted to do commercial leasing. So this is a massive topic. And for the leasing nerds out there, you'll know that you can take countless seminars every year on leasing and still feel like there's more to learn, because there's always more to learn. And of course, that's never been more true than the last couple of years. So I'm going to step back a little bit and take a real macro approach to get started. And I like to take a few minutes to do this. Not a lot of leasing lawyers do this, but now that I've been doing this for a million years, I think one of the things that is often overlooked, especially if commercial leasing is not in your standard wheelhouse, or maybe you've only been doing it for a few years, is I like to look, before you dig into a lease that's been given to you, who are the parties? Why are they doing the lease? Where are the premises? What are the market pressures? When will rents start? These are the big questions that you need to have firmly fixed in your mind before you can really best serve your client in that lease review. So the first question, who are the parties? Who's the landlord? Who's the tenant? What's the relative bargaining powers of the parties? And as a sidebar, who are the lawyers representing the parties? So I say that because if you are negotiating against someone who knows leasing really well, and you know leasing really well, the transaction will go relatively fast. Now that's, take that with a grain of salt, depends on the scope of, the transaction and the particulars of the deal. If you are negotiating against someone, or you are someone who does not know leasing well, then that can make things take a little bit longer. But don't be distressed, if you don't know leasing well. Hopefully these pointers will help you. And then as a backup plan, the secret weapon in your pocket is you give me a call and say, I'm doing a deal and I don't understand this point. And I'm always happy to talk to lawyers when they have leasing questions. So who is your client? What type of business does your client run? This is really important. And part of this is modulating the advice you give to your client, modulating your response to the particular deal transaction. So for example, is your client a small entrepreneur? Is your client a large institutional investment company? So are they a landlord? Are they a tenant who rolls out 100 stores a year? You need to get some sense of your client's prior knowledge of leasing, because that will really indicate to you how to best advise them. What are your client's expectations about the lease? Do they have timing issues? What are their pressures? Again, how sophisticated are they? Who are the decision makers for your client's team? So if you're dealing with a tenant, I've had the experience where the CEO in a startup hands the lease to the office secretary, who sends it to me, and then I'm talking to the office secretary. And by secretary, I mean, the receptionist, the executive assistant, not a person who has decision-making authority. Make sure you know who that person is. It sounds kind of basic, but you'd be surprised, especially with young companies, that they don't really have real estate department. They don't really know a lot about what they're doing. And so you want to make sure you have a conduit to the decision maker. And, again, how big is the company? Who's your point of contact? Are you dealing with the general counsel? Are you dealing with a person who's not a lawyer, dealing with a lawyer who doesn't have any real estate experience? What is your client's business? Are they a small bookstore? Are they a large national retailer? And what is the product they're looking at? Are they going to do a retail lease, an office lease, an industrial lease? And we'll talk in more detail about what each of those things are. And that will help you a lot. So for instance, going back for a minute on the tenant side, if your client is a small business person, they're not going to know probably anything about leasing. So my feeling is your job is to give them sort of some basic understanding about leasing. For one thing, a lease is different than any other service contract in the sense that once you sign a lease for 5 years, as we all discovered very painfully in the past 2 years, you are stuck paying rent for 5 years, regardless of if it's no longer convenient for you to have that space. Many service contracts are turnable by either party on 30 days notice. So sometimes business people can go into this with the not understanding sort of the weight of this. And I always say to the person who's not experienced, a lease is more like a mortgage than any other agreement that you have. You've signed up to pay this amount over time for property interest that you've been granted. So that's an important concept to make sure your client who's not familiar with this understands. If you have a landlord client, presumably there might be some repetition in representing them, and there's some value adds you can give in terms of understanding their priorities. But there's a lot of different types of landlords. I have landlords who are small families, basically, who bought a property, and in San Francisco, it's accrued and grown in value over time. And now they started out leasing to small mom and pop businesses, and now their tenants are Google or Airbnb. And so sort of it's been interesting over 20 years to kind of grow with them in terms of who their tenants are. Is your client a large institutional investor? If they are, they're going to have some very significant risk parameters that they're not allowed to take on. Because ultimately a large institutional investor, normally they are an advisor to a pension fund client, and pension funds are very conservative for obvious reasons. Is your client what I call the cowboy entrepreneur? And by that, I mean an individual or a family that invests in real estate as their family business, and they are often willing to take risks that other types of landlords would not take risks, because they're kind of gambling. They understand that this is can be a risky business, and they're kind of okay with rolling the dice on some issues. And you as their lawyer have to kind of get a little comfortable. And I come from the institutional landlord world, so for me it took a while, that they're taking risks that many landlords wouldn't take. So that's also something, again, you're kind of modulating your advice, right? So tenant team, again, make sure you know who the people are, the key decision makers. If there's going to be substantial construction, do they have a facilities team? Do they have an in-house construction department? Do they have in-house counsel that you have to run through? Is there a broker involved? That broker can be helpful or not helpful, depending on how much experience that person has. If you have a client and you're representing a tenant, as so often happens, a lot of tenants only do one lease, every 4 or 5 years. And so if they are in charge of a big construction project, they're immediately in way over their head. So you as their lawyer can help them say, you need to hire a project manager. You need to get a construction expert in here to help you, because running $1 million construction project is probably outside the expertise of your current team. So those are ways you can help. They're not, strictly legal. Okay, the second thing, why is your client doing the deal? What is their goal? Again, is it a retail tenant opening their 100th store this year? Is it a small bookstore opening their first bookstore ever? And what are their pressures about why they need to be open by certain dates? Is it an office tenant whose lease is expiring in their current space on a certain date, so they got to be in the new space by a certain date? So what are the pressures on your client in terms of the deal? It's really important to understand that, so that when you're negotiating a lease, you can make sure you protect your client in this regard. Sort of a sidebar on this is your client's goal is, say, to open a veterinary hospital in a shopping center. And you understand that this is their 50th one they've done. Is that a permitted use? Are there CC&Rs which would prohibit that use? So before you can even get off the ground, there might be some pre-lease work that needs to be done to make sure that your client is allowed to use the premises for the reason they are doing the deal. And in that regard, it could be that there are zoning variances that are required, and you might need to get a land use council involved to assist you. Many cities have zoned different parts of the city for specific uses. And so if you want to do something else, it's not permitted, you have to apply. You then need to have in your lease protections for what if you don't get that variance. So again, these are all ways to educate your client. It's also going to change the timeline. If you've got to submit to a government authority to get a leasing, a zoning variance, you're not going to be in tomorrow, right? That's not going to happen. And so setting expectations from the beginning, this is a possible roadblock. This is the time associated with the roadblock. And again, you may need to get land use counsel involved, unless you already are a land use lawyer, to help you in this regard. We have a lot of this in San Francisco several years ago, where everyone wanted to convert what was previously R&D space, light manufacturing space, to office, because all the high techers were coming in. And so this would put a drag on deals as you tried to figure out the zoning issues. Density requirements, don't care about that so much anymore because no one goes to the office. But back in the day, this was an issue in terms of maximum amount of people who could be in an office space. Again, that will probably come back again, but not so much right now. And then what are the market conditions? This is really important, and this varies over time. We're in a really interesting market condition right now. So, relative powers of the parties, is it more pro landlord or more pro tenant? And this is where you can really add a lot of value to your client by staying up to date on what market conditions are. And there's a couple different ways you can do that. One is you can call your leasing buddies and ask them what their opinion is. The other, you obviously read the papers, subscribe to BizNow. There are a lot of things that you can do, but it's important for your client to understand. And of course, this may vary. If your client is Target, if your client is Whole Foods, they may be somewhat indifferent to market conditions, right? Because they're the 800-pound gorilla, same like Starbucks. But if you're just an average tenant, it's a very pro-landlord market right now. And this is very surprising to a lot of people. We thought with the pandemic a year ago, we would have said, any minute now, it's going to flip and be a tenant market. And with very few exceptions, throughout California, throughout a lot of the United States, it's really still pro-landlord. And I'll talk about that at the end if we have time, sort of about the pandemic and force majeure and what's happening with that. But it's important for your client to understand. So I'll give you an example. In 2008, the Great Recession, that became in the next few years, a very pro-tenant market. And during that time, you could ask for things and get them from landlords that now are virtually unachievable. And the classic one would be in California, Prop 13 protection. So Prop 13 protection, as we all know, basically says that if an owner sells the building, it can only be reassessed at that point. And there's a few other exceptions, but that's the main one, that basically increases in taxes, real estate taxes is capped at 2%, unless the change in ownership happens. When that happens, then there can be a significant increase in taxes, right? If the building's been a long-term hold, the building has been owned by ownership for a long time. This is very common in San Francisco, where you have a lot of families who've owned buildings for decades. Then someone passes on and they go to sell the building and there's a dramatic increase, or in very volatile markets. The Metreon, as you all know, probably in San Francisco, changed hands multiple times. And a couple of those times, the increase in taxes was astronomical, and that is passed through as part of common area operating expenses to tenants on a straight pass-through basis. So your taxes can increase a lot as a tenant. And so if it's a pro-tenant market, you can negotiate that you get some protection from that. You could say, I will only pay 2% increases in taxes throughout the whole term. I don't care how many times the building changes hands. That's very hard to get. Or you can say, I won't be subject to the first change in ownership. Or you could say, no event will my costs exceed X dollars per square foot. Lots of ways to slice the pie. The point is that in a pro-tenant market, that might be achievable. Some negotiation on that point might be achievable. But in a pro-landlord market, there's no point even asking, unless it's in the letter of intent. There's no point in asking, and there's no point negotiating. There's no point. You should tell your client, like, this is a possible cost you might incur, and you should plan for, the possible scenario. But in terms of negotiating it out of the lease in a pro-landlord market, not going to happen. And so this is, again, you're adding value to your client by understanding the market conditions and how it affects the lease negotiation. The next important topic, where is the project? Is it in, and I've got a bunch of slides I'll just run through, is it Main Street, little bookstore on Main Street? Is it a grocery anchored center? Is it an outdoor shopping center? Is it, the Beverly Center? Is it a little retail on a main street in San Francisco? Is it office space? Is it high-tech office space? You can see, total open plan. I have clients who have an 80,000 square foot floor plate, and, there's conference rooms mingled in, but it's a lot of these bench tables. Or is it like your old-fashioned law firm? Individual offices, perimeter windows, where that's where all, for instance, in a law firm, that's where all the attorneys are, with the support staff in the core. So is it a warehouse? What kind of warehouse? Is it R&D? Is it life science? So there are special issues in connection with labs, cold labs, clean labs, etc. So it's really important that you understand where are they going. And again, there's market forces associated with that. There's lots of issues. It's a whole separate seminar, but it's important to know where is your client going. Condition of the premises. And again, a little bit of this is pre-lease due diligence. And as part of my MCLE materials, I provided some checklists of questions to ask the client, questions to make sure that the client has asked the landlord, et cetera. But you want to make sure that your client understands the physical condition of the premises. You know, is it a vacant lot right now? And the landlord has promised to build a 10-story multi-use building in which the ground floor retail will be your client's coffee shop. Is it a first generation, just completed construction, totally in compliance with laws, bright new, shiny shopping center, and which we would call first generation? And is that where your client is going? Obviously, you want to make sure you have in both those scenarios, very clear description of what the landlord is obligated to deliver to your client. It's often the lease is signed before that stuff is done. So you want to make sure you have a way of holding the landlord's feet to the fire in terms of what they were required to deliver. Or is it older space? I mean, certainly in our cities, even in our suburbs, we have buildings, you know, from the 20s, 30s, 40s, very old, that have been used for whatever over time. What is the condition? What is the hazmat situation? What is the disability access? What are the rules that apply? So in San Francisco, we have San Francisco rules. We have state of California rules. We have federal rules. So a lot of jurisdictions are like that, where there are going to be local disability access rules that may apply. And you need to make sure that you understand whose obligation is it to do that, to make sure the premises are compliant with Disability Act rules. What is the rentable square footage? So depending on the product that you're leasing, whether it's retail, there would be a gross leasable concept. So it's basically like in, you know, whenever you learned geometry the first time, right? If it's a square, you know, length times width, that's gross leasable. But if it's an office, we have this tricky thing called load factors. It's like a fake number that you multiply the actual square footage of the space by to come up with the actual rentable. That's what you're paying rent on. And so the load factor in some leases in New York City can be like 27%. So, you know, that's a lot. In San Francisco and other cities, it might be between 7 and 17%. So making sure you understand how that number was calculated, and that you're okay with that. And there's something called BOMA, which is a building organization that has a measurement metric that you'd have to become familiar with. Does your tenant need to measure the space, et cetera? So there's a lot of stuff associated with condition of the premises. Again, we could do seminars on each of these things. So types of leases. So now we're getting into sort of more of the nitty gritty of the leases. So there are many, many kinds of leases. The three main ones are office, retail, and industrial. Each of these three types of leases, in addition to the product that goes into it, meaning the type of tenant that goes into it, it has a different economic structure. Now, there are many other kinds of leases. There are farm leases, there are build-to-suit leases, there are ground leases. And again, all those have different economics, but for our purposes, the most common ones you'll probably see are office, retail, or industrial. So like I said, each of these has their own particular economics. So an office lease is often called a gross lease. These terms are muddled all the time. So you may hear people using the terms. Make sure that they give you a definition of how they're using the term, because often, especially brokers, conflate these terms. And I've often gotten confused by my understanding of a term and then the way someone else uses it. So make sure that you understand. Don't feel like I shouldn't ask the question. Ask the question. So a gross lease means there's base rent. So, you know, you're paying $10 a square foot. And then there is operating expenses. That's the cost for the ownership to run the building. The janitors, the utilities that are not separately metered, the insurance costs for the landlord to insure the building, real property taxes. And in a gross lease, there's a base year. And all those numbers that I just mentioned are baked into the base rent. So the tenant pays increases over the cost from a base year. Then there's something called modified gross, which is the same thing I just said, except that certain costs are segregated out and paid directly by the tenant as a straight pass-through. And typically those are janitorial and utilities. So everything's on a increases over a base year except for janitorial and utilities. And you see a lot of those types of leases in office complexes in big cities that they want to segregate out janitorial and utilities. The base year is usually the year in which the lease is signed. However, as it gets later into the year, tenants will try to push this forward. So if we're doing a lease signed in the fourth quarter of 2019, the tenant would push for a 2020 base year. And they probably won't get much pushback on that. That's pretty common that as you get to the end of a year, you want the base year. The idea is for the first 12 months of the term, it's just base rent, no operating expenses. And then there's retail, which is usually a pure triple net. So again, all the costs the landlord incurs in maintaining the shopping center or the property are passed through pro rata. The tenant is 10% of the property. They pay 10% of all of the landlord's costs. And for all of these types of leases, again, this is sort of a pre-due diligence type checklist, pre-lease checklist. Get the landlord to provide you some historical information on what these costs run, because they vary enormously. So in an office lease, it might be $1 per square foot, the increases over operating expenses. That historically, that's the way they've run. In a retail lease, maybe it's $3 a square foot, maybe it's $15 a square foot. Obviously, that has a huge impact on the tenant's budget. So make sure that you get some sense of what those numbers are so that your client is not surprised by that. And then, of course, there's, lots of negotiation about trying to cap that and whatever. Again, could do a whole seminar on this. In retail, it is often the case that the tenant will pay percentage rent. So typically what this means is all the gross sales from the premises, once it reaches a certain number, which is called the break point, the tenant pays a percentage of that to the landlord. And the idea is, if the tenant is being so successful in this location, part of that is because of the fabulousness of landlord's property, and so landlord should share in the profit from that. Percentage rent has become very talked about recently because of the pandemic. One solution that some landlords are using is to allow a period of time where the tenant just pays percentage rent. So they just pay 5% of all gross sales rather than base rent, to give them time to get started and established because of so much market uncertainty. And I'll talk about a little bit about that at the end. Some shopping center leases have other cost pools like merchants association. So it's not uncommon for a landlord to say, well, we have a merchants association. Each tenant has to chip in X dollars per year. And that's where we roll out the Christmas decorations in the mall. And, we put, President's Day sales, that type of thing. In retail, it's very common for the tenant to do its own construction. So if you're a Starbucks, you've built 8,000 Starbucks, you know how to build a Starbucks. You don't want the landlord doing that, right? The landlord delivers you whatever you've agreed the landlord will deliver, and then you're going to do your build out. For some retail tenants, especially like a clothing store or a bookstore, maybe that's not very dramatic, right? You're just putting up some shelves. Maybe a lot of your shelves are movable. So again, totally depends on the type of product that you're putting into the space. And industrial lease, or sometimes called warehouse leases, again, typically in pure triple nets, but normally the tenant has additional maintenance obligations. And this is true in retail as well. So if we're talking maintenance, in an office lease, the tenant normally has almost no maintenance obligations. Other, they have to keep their space clean and they can't go around busting windows or whatever, but they're not, fixing the HVAC or whatever. In retail and industrial, usually there's dedicated HVAC that services the premises and the tenant is responsible for dealing with that. Then in industrial, they have even more types of those obligations. And in industrial, it's very important to make sure, and this can happen in some retail cases, is the tenant one tenant, so a single tenant in the complex, or is it multi-tenant? In the case where the tenant in an industrial warehouse setting is the only tenant, they will probably have almost all of the maintenance obligations. So in that situation, the common area maintenance costs should be very low because the landlord's not doing any maintenance. The tenant's doing all of it. So you have to make sure those two provisions really sync up. You know, is it clear that the landlord's doing very little and what the landlord's doing can't be passed through to the tenant? Or is the landlord keeping some things? Like, are they agreeing to continue with landscaping? In which case they would charge the tenant, in that case, 100% of the cost because they're doing it. It's a single tenant. So those are all things to think of. And in industrial, life sciences, a few others, do they need any specialty improvements, specific racking, specific build out, cold storage, backup generator? Again, these can all affect the transaction, the timing, etc. And then, like I said, there's a bunch of other types of leases. If you get one of these, call for help because they're very complicated and have their own unique issues. So the next question for the client and for you to understand about the lease is, when will the premises be delivered? When will rent start? Is there any landlord work? Is there any tenant work? And there will be a direct connection between those topics and when rent starts. So for instance, in an office lease, the landlord is going to build out the space for the tenant according to the tenant's specifications. Rent should not start until the premises are delivered. You can't sign the lease today and say the rent's going to start on May 1 and the landlord is responsible for all the work that's estimated to take 4 months. How is it, right? Because then rent's going to start on May 1, the work won't be ready to be occupied until the landlord's work is completed. So you need to really make sure you understand the relationship between condition of the premises, who's doing what work, and when rent starts. On the other hand, if the tenant is doing work, the landlord is not going to say, oh, sure, whenever the tenant gets around to finishing their work, we'll have rent start, right? Because the landlord is going to say, that's out of my control. What if the tenant dilly-dallies around and doesn't get their work done in a timely manner? So the landlord is often going to say, I want a fixed rent commencement date for that tenant. So then the tenant has to go, well, I think it's going to take me X months to build this out. And so I'll agree my rent can be 6 months from the date we sign the lease. You know, the savvier tenant will say X months from when I get my permit. And then that'll go back and forth between when they're obligated to get their permit, et cetera. So this is probably the heart of the lease, one of the most important issues to make sure you have your arms around, and whether you represent the landlord or the tenant, that you're protecting your client in terms of when money's going to start. Again, we talked a little bit before about what are the pressures that your client is experiencing. If they're a retail tenant, are they obligated to open the store by a certain time? Do they have blackout periods? So most retail tenants will say, I will not open from November 1 to January 15. They don't want to open, be forced to, well, I should say they don't want to be forced to take delivery of the premises where they would be doing a build out during the holiday season. They want to wait until after the holiday season, unless they can guarantee themselves that they'll be open during the holiday season. So that's something to think about. You know, are there particular permitting issues? I talked at the beginning about, do you need to get a zoning variance? Do you need to get a conditional use permit? How does that affect the deal? In an office tenant, like we talked about, is there pressure because the tenant's current lease is going to expire? And normally what I say is, if the tenant comes to me and says, my lease expires in 3 months, so we've got time to negotiate the new lease, I say, talk to your current landlord right now about, will they let you stay over for a few months if necessary? Because even if I wave my magic wand and get the lease negotiated and signed in a few weeks, which is highly, highly unlikely, if there's construction that the landlord is doing for the tenant and there's delays, then the tenant is going to be stuck paying holdover rent in their current space or even getting evicted. And no one likes to get evicted. That's really bad. Another pressure that may happen, and it's happened to me several times in my career, there will be not right now, but in other moments, there will be intense pressure to finish a deal because the landlord will say, and it will be true, there is a line of tenants waiting around the block for this space. And if this deal, the brokers, God bless them, will put into the letter of intent, the lease must be signed within 2 weeks. That's very hard. So is that a pressure that's on the deal? So again, keep in mind, what are all the pressures out there? So I already talked about what is the commencement date, when does rent start, does the tenant have early access? What happens if the space isn't ready by the commencement date? What happens if it's not ready by a certain outside date? Could the tenant have the right to terminate the lease? So, I'm representing a landlord, just got the lease right now, landlord's doing the work, and the tenant wrote, if the premises aren't delivered to me within 60 days of lease being signed, I can terminate. So of course I've got to call my client and say, first of all, is 60 days realistic? How long do you think it's going to take you to do the work? And every landlord will then want a cushion. I'll say, well, it's going to take me estimated 60 days. No permits need to be pulled, so I don't have to worry about that. But I want a cushion because of supply chain issues, because all the crap is going on right now. So I will give them a right after 180 days, right? Because they want to give lots of protection. Another way to slice the pie is to say, I'll get as tenant 1 free day of rent for every day the premises are not delivered to me after a certain date. If the tenant's going to be in a holdover situation, you might say, landlord, you have to make me whole if you make me hold over my current premises. I will say that's a very hard sell. That is hard to get. But again, be thinking about the damages that your client's going to incur if they can't get into that space in a timely manner. Make sure you understand the expiration date. A lot of times that's confusingly drafted. People don't understand it. And so make sure that you understand it. Does the tenant have a right to terminate the lease early? That's not common. It should be in the letter of intent if it's a deal term. Because it's so material, it should be in the letter of intent. Some tenants will say, and in fact, I think I just got a lease yesterday, it was in the letter of intent, 10-year deal, but the tenant has the right to terminate after 5 years. And they have to pay some termination fees to the landlord, et cetera, but that's part of the deal. So again, what does your tenant need? What's their business model, et cetera? Does the tenant have a right to extend the lease term? Most tenants are going to want that right. It's very rare that a tenant doesn't care. Again, this should be a material term in the letter of intent. If they have an option to extend, how's the rent determined for that extension? Is the right personal to the tenant? Are there any hoops the tenant has to go through to exercise that right? So again, very important to the tenant that they have those rights. At the same time, you're thinking about, how long is the term? Can I extend the term? You also have to be thinking for your client's benefit, how do I get out of this lease other than an early termination right?
Joanne,
yeah, go ahead.
I had a quick question.
Sure.
If you could address, it was about letters of intent.
Yes.
And if you can fit it in at some point on whether to make them binding, how to make them binding, or what the strategies are on that type of thing with letters of intent, if you don't mind.
Okay. I would say that letters of intent should always be non-binding. With that being said, every letter of intent I get is non-binding, but there is the element in deals of what I call moral suasion. And that is, if it is in the letter of intent, even if the letter of intent is not signed, and often they're not signed, it has a lot of weight in the transaction. So if there is an option to extend in the letter of intent, and that's not in the lease, even if the letter of intent wasn't signed, even if it's non-binding, there will be a lot of negative emotions that are generated if it's not in the lease, and it will not be understood by the tenant. Why is that not in the lease?
Okay, so you might say that the letter of intent is beneficial to get the material terms together, but as far as like expenditures, investigating environmental issues or whatever else, not real useful as far as that goes. Is that what you're saying?
I don't really see that.
Mhm.
Sometimes, especially the big national tenants, want what you would think of in the purchase and sale context as an option. They want their due diligence period baked into the lease, and they will have a period before any money has to be, before they incur any charges, where they get this period to, 60 days, 90 days to look at the title documents, and they have a whole checklist. If you're a national tenant, you have a whole checklist. You have to review
Right.
all these things, and they'll sign the lease first, and they'll incur the costs, and then they have an absolute right to kick out if something similar, again, to the purchase and sale, where there's the conditions before it goes hard, so to speak.
Yeah.
That is only like in the national tenant setting, though. It is not typical in your ordinary lease that you have sort of a kick the tires period.
Okay. All right. Thank
The
you.
only typical kick out would be if you need a zoning variance
Right.
and a conditional use permit. But then again, you have to, if you're representing the tenant, make sure it's really clear you get to kick out if you don't get your CUP. And if you're the landlord, make it very clear what it means to be diligently attempting to getting the CUP. So we had a situation where, I worked really hard for the landlord, carefully drafting that conditional use permit. Like, you've got X days tenant, you have to be diligently attempting. Diligently attempting means, and I had this whole long definition. So then it got to the point where the time periods had, and if the tenant doesn't get their CUP, they can kick out for nothing.
Right.
So it came to our attention the tenant was not diligently attempting. So now you've got the burden of proof. And so fortunately, what we had was a letter from the government agency saying, tenant, we receive your application for a conditional use permit. We might agree to it, but we need to see 1, 2, 3, 4, 5 from you, and you must submit this to us by July 31. And if you don't, your application is null and void and you have to resubmit. And the tenant didn't submit by July 31. So I was like, that is a clear case of not diligently attempting. You, tenant, have lost the right to terminate this lease for this reason. And, I had to write this long, detailed letter to the tenant justifying it. So these types of issues are really important. None of that level of detail was in the letter of intent, right? It was just like something in the letter, oh, we have to get a CUP. We might have to get a CUP. There was no detail about how that would happen.
Yeah.
So we kind of had to invent the whole thing.
So we do have some other questions streaming in.
Sure.
I'm gonna push them back. I'm gonna let you continue on your thing, but thank you for taking that one, and we'll get to those
Sure.
in a minute. Okay.
Sure. So again, quickly, assignment and subletting, its own seminar. The main issue is, does your tenant need flexibility? Are they a startup? So startup means, Google's going to buy them someday. They're going to get merged into some other big company someday. And you want to make sure that you don't get tripped up and need to go to the landlord for consent because that merger is deemed an assignment of the lease. So a few other questions in there. So I want to make sure and talk about the financial stuff a little bit. So obviously we talked about there's rent, base rent, plus CAM or operating expenses, security deposit, tenant improvement allowance. Make sure you understand what the base rent is. Make sure you understand whether there is a rental tax in your jurisdiction as there is in San Francisco. And if so, what does the lease say about who pays it? I can tell you in San Francisco, this was, a shock to our nervous system. I mean, states of Florida and Hawaii have had it a long time. San Francisco adopted it a couple of years ago. It was a little, who's going to pay for it? Quickly shook out the tenant pays for it, period. The landlord reports it, the income, and pays the tax to the authority, but the tenant pays it to the landlord, reimburses the landlord. Are there escalation clauses? So rent increases by 3% every year, or is there a CPI clause, which you see sometimes? Rent increases at the rate of CPI, not to exceed a number, usually 3%. Are there notice and grace periods if you default? In this day and age with mechanized rent payments, it's rare that people who are sophisticated miss their rent, and it's normally an accident. And so you want to get a notice before you get in trouble. Operating expenses and CAM, we talked about that. So the other big financial component, tenant improvements and allowance. Who's paying for what when? Again, this is its own separate thing. You just want to make sure that you understand if the landlord is going to be reimbursing your tenant. When do they have to submit all the bills? Is there an outside date? Normally there is. Is that a date that works? As we saw during the pandemic, is it subject to extension by force majeure because you couldn't do your construction because everything was shut down? That's important. If the landlord is doing construction subject to a cap, meaning the tenant has to pay everything in excess, what control does the tenant have over that excess and how it's determined? Make sure the tenant doesn't just get a bill for $1 million, right? That they have had an opportunity to maybe change their mind. They don't need the gold-plated fixtures in the kitchen after all, because they're going to have to pay for that. They want to value engineer or lower the cost of the TIs before they are expected to pay money. And the big topic, again, it's a whole other webinar. How are the tenant's obligations under the lease securitized? 3 common methods that you see most often: deposit in the form of cash, letter of credit, guarantee. I will say, in terms of a letter of credit, that is its own very complicated scenario. It takes a lot of time to get it going. So make sure that as soon as lease starts to seem like it's really going to happen, you have talked to your client, because there's backroom stuff that has to be done at the client with their bank to get this issued. You want to get the form of letter of credit attached as an exhibit to the lease and pre-approved by the landlord. Once the lease is signed, it's very hard then to make any modifications to that. There's all sorts of nuances where, if you're a relatively new company, a startup, maybe you have to have 6 months cash security deposit, but then you can negotiate a burn down. So if you've been a good tenant, you've not been in default, etc., then your obligations can, you'll get a refund of a portion of that security deposit over time. And that's not uncommon. Often there will be credit thresholds or benchmarks you have to meet if you're a new company before you would be allowed the return of that security deposit or a portion of it. So those are all things to keep in mind. So this is always the question my clients ask: how do they know how much of a security deposit to ask for? So these are the 3 components that landlords look at. They look at the amount of the broker commissions, because they want to make sure that no matter what, they're going to get that. The amount of the tenant improvement allowance, and the creditworthiness of the tenant. And the last one will affect more than any other, the amount of the deposit. So if you have a high-tech company that, as often is the case with high-tech companies, has a lot of cash but is in the red and has been for years, again, it's a long time before these companies become profitable, which blows my mind, but is in fact true. You've got $1 million build out. The landlord may in fact ask for a letter of credit. And again, the preference is letter of credit because they most of the time are bankruptcy proof. That is, the landlord can draw down and keep the proceeds even if the tenants declare bankruptcy. Whereas cash becomes part of the bankrupt estate. And so that's no good to the landlord. So you've got $1 million improvement. The landlord may say, I want $1 million letter of credit. And if certain, again, credit benchmarks are met at a certain point, I will agree, once those tenant improvements are completed, to reduce the amount of the letter of credit by a certain amount. But again, this is all highly, highly specific. If you're talking like my little bookstore, typically the scenario would be my little bookstore guy. This is his first bookstore. He's got some personal assets. Maybe he owns his home, or he and the bank own his home. So he would often be required to maybe put up a couple months, and the landlord's doing no work. There's no tenant improvement allowance. He might have to put up a couple months of worth of rent as a security deposit and provide a personal guarantee. So it's very common for a situation where you have a retail tenant that a personal guarantee is provided. So as part of this process, there's a letter of intent that's entered into, and at that point, normally the landlord will say something in the letter of intent like security deposit dependent on landlord's review of tenant's financial statements. And so the tenant needs to get those financial statements to the landlord as soon as possible. That may involve having the landlord sign a non-disclosure agreement. That may involve negotiations. So you want to get that there to the landlord as soon as possible. And then the landlord will, again, look into their crystal ball and figure out what is an appropriate number. You know, if you are a mega company like your Bank of America or Wells Fargo, your security deposit may be zero, regardless of the deal specifics, because your credit is just so good that the landlord is comfortable that if there's a problem at this one location, the tenant's good for it. So again, there's a lot of metrics that go into that. So that was my super fast skinny on all those things. And if there's questions, I'm happy to answer any of them. So just a year ago, I gave a presentation on the evolving case law in connection with COVID. And it was a very exciting conversation. I attended many similar webinars, and we just did a deep dive into these cases, and something I hadn't read so many cases since law school. And I can tell you, you don't need to worry about it, because the bottom line is most of the cases, the landlords are winning. They just are. And some big guys like The Gap have sued their landlords across the country. Valentino, many other big famous tenants have sued. They've all lost. There is one outlier case, a couple outlier case, but the most significant one that got a lot of buzz was the Heights Restaurant Group, in which a bankruptcy court, and so this is the way it always gets distinguished by the other courts, the bankruptcy court in Illinois said that a partial rent abatement was okay because the restaurant was only allowed to operate for takeout. So for those leases that were in the bankruptcy, they still owed a pro rata share of their rent, not the normal rent. The other big case was the Cafe Nero case in Boston, which was 100% for the tenant. But again, it's mostly all for the landlord. So a year ago, we were talking about, oh, well, there will be these risk sharing provisions in leases, and it'll say that if the tenant can't operate, they won't have to pay rent, yada, yada, yada. Pretty much not happening, except in some very unique markets. As an example, Central Business District, San Francisco, is just taken a brutal hit by the pandemic. And I know you guys are all in Contra Costa, so you probably see the local news and you see the newspapers, and they all are talking about the horrific rise in crime, especially targeted at retail, the horrific rise in homelessness, which, let's face it, was never great in San Francisco, but has just become brutal during the pandemic. And as a result of that, and as a result of the fact that the vast majority of large employers in San Francisco are high tech, and most of them have not required return to office. The last statistic I saw in January was that of the space leased, so we're not even talking about vacancy, of the space that's leased, less than 20% of workers are going to work. So that's not enough to sustain retail businesses in San Francisco. And so in that unique setting, there is leverage, and I represent some landlords who are trying to proactively work with tenants to get retail tenants back into downtown in the Central Business District, and are agreeing to make some rent concessions. But what I understand from my other colleagues, leasing colleagues throughout the country, it's only in these little, micro crappy retail markets that's the case. Most of the time, that's just, we're not doing that. A year ago, I would have said, I'm spending all my time drafting these COVID rent relief clauses. It's not happening. So with that, I will close and let you guys ask questions.
Okay, Joanne, I got a quick one. Have you seen any cases come through about health clubs and COVID relief or frustration?
There were some, there have been a number of, you mean like gyms?
Yeah.
There have been a number of gym cases and they've lost.
Interesting.
So the reason for this, if you're a leasing nerd like I am, you have to think of it as, I always make the analogy, you enter into a lease as the tenant, you are receiving a property right. unless the landlord actively interferes with that property right, you have that right. And so you have to pay the rent for that right. And I liken it to, you have a car, you have a loan on your car. You go to take your car out of the garage one day, the town has come through and closed off your road because they're repaving it. And it's going to be closed for 30 days. You can't drive your car because you can't get to the road. And you call up your bank and say, I can't get to the road. And they're like, I do not care. Pay your car payment. Like, I literally do not care. This is of no interest to me whatsoever. And that was really the landlord's point of view. Listen, unless the landlord actively locked the building and said, you can't come in because of COVID, which very, very few landlords did, then as a result, you have your property right. You temporarily can't access it, but
You
sorry.
still have it. Yeah. So we have a couple questions here. This one from Angela Yu, one of my colleagues on the Contra Costa Bar Executive Committee. Does a retail tenant generally have any legal recourse against holdover rent on the ground that it was negotiating a lease extension at the time the natural expiration of the lease occurred?
If it says that in the lease,
Yeah.
sometimes tenants try to put that in the lease.
Mhm.
If I'm the landlord, I say no, because it's too hard to know what people think is negotiating. I would say generally no.
Okay. I thought in fact you actually addressed that earlier, that you want to make sure you get an extension before you start negotiating when you're 3 months out.
Well, it just helps the landlord in terms of the landlord planning, and it helps just I have a friend a lawyer friend, and she says, often if you just bring donuts over and have a chat, it'll just come out better. So to judge your landlord and figure out whether it should be fresh mango with lime as opposed to donuts, but giving the current landlord a heads up, like I might be in trouble. And if the landlord says, I do not care, get out on this date for whatever reason, then you have to strategize with your client about how can we help you. So if they're in office, maybe everyone can work from home. If they're in office, maybe you can get some WeWork space.
Mhm.
If they're retail, that becomes very hard. But if the landlord, then it's a calculus. What are my damages?
All right, we got another one here. This is a quote. I've seen recently that if the lease terminates prior to the natural expiration of the term, then the tenant must pay unamortized tenant improvement allowances. Any thought about that?
Very common.
Okay.
Unamortized broker commissions, unamortized TIs. Yes, that's very common.
Okay.
So the metric would be, number one, the difference between all the rent for the rest of the term minus what the landlord could get, the tenant proves the landlord could get if they reasonably used efforts to relet. And then typically unamortized TIs and broker commissions. And then sometimes landlords try to claim, well, I had to change it from a Japanese restaurant into a Victoria's Secret, and that cost $50,000, and so you have to pay me for that too.
Right. I've seen that. Those are the questions pending. Anybody else, if you have a question, throw them into the chat. I really, really appreciate everything that you commented on today, Joanne. It's been a real pleasure. You always, every time I get kind of stuck, I try to track down Joanne to see if she'll help out a little bit.
And again, feel free to email me or call me anytime. I'm happy to answer any questions that I can. And leases are hard. I mean, they really are. If you don't do them a lot, it's very overwhelming to get a 60-page lease and understand, and also you get these varying requests from your client. I have a tenant who emails me, it's only a 2-year lease, it's only 1,300 square feet, spend less than 1 hour on this, which is very hard for me. And you're like, okay, this is what you get for 1 hour. And they're like, set the clock. And I type my notes as fast as possible. That's what you get. So I'm not guaranteeing anything.
I always think that the clients I mean, if they're not really used to doing lease negotiations, their expectations are really out of whack with how long it takes, how many hours it takes and things like that. So I'm sure
And
you're
that's
really
another
good
thing
at
I didn't talk about is setting client expectations about how long
Yeah.
it takes to do a lease.
Yeah,
And
and the cost.
it's a delicate balancing act because some clients, they're like, it has to be done. And so you don't want to say like, that's not going to happen. Like in my mind, that's what I'm thinking. That's not going to happen. Like you
Mhm.
can want it all. I had a client come to me December 2, this lease needs to be signed by the end of the year. And I'm
Mhm.
thinking that's not going to happen.
Yeah.
And they couldn't make up their mind whether to hire me. They had to go to an internal process. I don't get anything December 15. Has to be done. Quick, there's holidays in there, right?
Yeah.
Has to be signed by the end of the year. And I'm like, trying to set expectations, trying to listen, I can do my part, as quick as I humanly possible.
Yeah.
But once I send it to the landlord, it can take from 2 to 4 weeks before they get back to us. Same if you're sending it to a big national tenant, like your cowboy entrepreneurs doing a deal with, AutoZone or Liquid Liquidators or some big place. And, you send them back comments, it could be 3 months before they've got 100 leases. So, it's hard to set expectations. On the other hand, you kind of have to try and figure out a way to gently break it to them that this is going to take time. And again, to set expectations if their current lease is going to expire as soon as possible, getting conversations with the current landlord about it.
Well, we do have a lot of compliments here. Just saying what a
Thanks.
great presentation, very clear, concise, informative, a lot of things like that. But we don't have any more questions. So I think
Okay,
what we're
so
gonna
the
do-
MCLE materials that I provided, I sent to JR. There's some checklists. And I find these super helpful. And I know you guys probably seen the study about the surgeons who have the checklist, because it's hard to keep all these things straight in your head. And if you have a checklist and you can refine it over time, can really help you make sure you're comprehensive when you're allowed to be comprehensive in your review.
And that written material will come out, and we'll be sending that out to all the attendees. So you'll get that and follow up with Ann if you don't end up getting it in the next 3 or 4 days. Anyway, thank you so much, Joanne. Always a pleasure. Sorry, I'm going to miss you this spring at the wellness event, but we'll see you soon, hopefully.
Okay.
All right.
Thank you.
Adios.
Adios.
Thank you, everybody.